to Crime in Court. This is the 1996 Menendez brothers trial. However, we're not actually going to be reading through the transcript today because we have a press conference from Los Angeles District Attorney Nathan Hochman. He has an announcement on the Menendez brothers. So, without further ado, let's get right into it. Please hit that like button and let's get started.
The second track is a petition for clemency that the Menendezes have taken directly to Governor Newsom. Governor Newsom has the constitutional power, and it's unilateral, to grant that petition of clemency and commute the Menendezes' case and release them immediately. He has that power today. He's had that power since 2019. He can exercise it. However, he has no deadline. There's no court hearing, and there's no appeal from his exercise of that power. And the third track is a track called resentencing. Resentencing is a somewhat California notion. There's not too many states that have a resentencing statute. The resentencing gets triggered by a district attorney's motion, or in some circumstances, the motion of a court. And that motion, unlike a habeas motion, where a habeas motion will focus on the trial itself, a resentencing motion focuses on that trial but goes beyond that and deals with rehabilitation and other factors. Today we're going to focus in two different things. The first is, in order to explain the procedures that the Menendez case has gone through, we have created a video that can be accessed at our website, which is da.lacounty.gov. Again, that's da.lacounty.gov. And that video actually does an anatomy of the Menendez case.
So I went on their website and I have yet to find it. I will do a much deeper dive and look for it and possibly go do that in a different video just for time's sake right now.
Takes the case from the murders itself back on August 20th of 1989 through the investigation into the charges that were filed in the arrests. Then it looks at the motions that were filed by the Menendezes prior to the trials. Then it looks at the first trial, which resulted in hung juries. Then the second trial, which resulted in convictions in hung juries. Then the second trial, which resulted in convictions for first-degree murder of both Jose Menendez, the father, and a separate first-degree murder conviction for Kitty Menendez, the mother, as well as a conviction for conspiracy to commit murder and certain special circumstances allegations of lying in wait and multiple murders. That video then continues on, though. It goes through the penalty phase, where the Menendezes were either facing the death penalty or life without the possibility of parole as determined by a jury. Then the sentencing. Then it actually goes through the various appeals, the direct appeals, all the way up to the California Supreme Court. The first habeas petition, again, with the California Supreme Court. The federal habeas petitions with a U.S. District Court and a Ninth Circuit Court of Appeals. In all those situations, as you will hear, the Menendezes have raised many of the same exact arguments that they raised in the current habeas petition. Those arguments have been heard by a variety of courts, from the trial judge to the direct appeal Court of Appeals in California Supreme Court, to the California Supreme Court again, to the federal courts. They've considered these arguments, and they have been routinely and repeatedly rejected. So we have the video that is coming out and go through this procedural history so that people can actually learn from the Menendez case and help and actually educate themselves on the criminal justice system. What I've said very often is, if the Menendez case is the portal by which people come into the criminal justice system and show an interest in it to find out what's happening, then hopefully they will educate them further about what happened not just in the Menendez case, but cases, criminal cases that are occurring throughout this entire county, this state, and this country every single day. So the video is coming out today, and it'll be out on our website. The second thing that we have done today is that we have filed an informal response in connection with the habeas motion. As I mentioned before,
Oh, that's excellent that sorry, my computer's being really slow right now, and I don't understand. I think we have too many things streaming at the time, or at the moment. So I apologize. I'll turn my camera off when I've got the video going. But I guess we're just finding out now that they are finally responding to the habeas brief. So let's see what he has to say about that.
there are these three parallel tracks: the habeas, the clemency, the resentencing. Again, the clemency is up to the governor. Resentencing we will be dealing with in the future, in the next coming weeks, with our response. But today we have filed the informal response on the habeas petition. Now, something you need to know about a habeas petition. It's not the direct appeal. The Menendezes have already had their direct appeal through the California Court of Appeals and California Supreme Court, and they have lost. They've even had one level of California habeas, which they lost, and one level of federal habeas, which they've also lost. So now they've come back for a second California habeas petition. And in coming back for that, they have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Now, in a habeas petition, there are very rigorous requirements to actually get that new trial, which makes sense because you've already gone through all these different layers of review. And if you've been rejected time and time again, at some point the system says that unless you have something very new and very compelling that is more likely to change the outcome of this case, then we are going to again reject your habeas petition. So when they come out in this case, they come out with two new pieces of evidence. One piece being an undated photocopy of a letter purportedly sent by Eric Menendez to his cousin Andy Cano at approximately December 1988, although there's no date on the letter, in which it discusses sexual abuse that was being experienced by Eric, perpetrated against him by his father at that time. That's the one piece of evidence that they've come forward, but they also came forward with a second piece of allegedly new evidence. The second piece of new evidence was a declaration by Roy Rossello, who basically said that in the early 1980s, he had been sexually abused by Jose Menendez. But the standard to actually have a successful habeas petition requires that you meet all of the following requirements. You have to show that it's new evidence. You have to show that it's timely, that it was evidence that could not be discovered at the time of the trial, but only could be discovered after the trial. You have to show that you did not engage in any substantial delay between the time you learned about the evidence and the time you brought your motion. The evidence has to be admissible, and the evidence has to be credible. Now, the overall argument about this new evidence, again, new evidence effectively dealing with sexual abuse that Eric Menendez experienced by his father, or a gentleman named Roy Rossello experienced by Jose Menendez, the defense has now argued the following. They've said to resolve this case, jurors had to decide a single critical question. Was Jose Menendez molesting his sons? The problem with saying that that is the critical question in the Menendez trial is that it's wrong. The jury never, in any of the two juries, had to resolve the question of whether the Menendez brothers were sexually molested. In fact, the counsel, Leslie Abrahamson, 30 years before, during these trials, properly framed where sexual abuse comes into play. What she said back then is that we have never said that because you're abused, you're justified in killing your abuser. We didn't argue that, and we never will. Well, 30 years later, apparently, the Menendez counsel is arguing just that. Because what the jury had to figure out is on the night of August 20th, 1989, did the Menendezes conspire to kill both their father and their mother that night? Did they in fact kill them? And what was their state of mind at that time on the night of August 20th, 1989? Did they engage in these killings willfully, deliberately, and with premeditation? Or was it an act of self-defense? They had an actual fear of imminent harm, that both their father and their mother was going to kill them, and they acted in self-defense. The sexual abuse part, as Leslie Abrahamson recognized correctly back then, was not a fourth question for the jury to answer. So when we look now at the factors dealing with this new evidence, we can go through these factors. Timely evidence that is discovered after the trial, for which there is no substantial delay in presenting it. Well, if this letter, supposedly dated December 1988, written by Eric Menendez to Andy Kano, is to be believed, and that it was actually sent at that time, here's what we know. We know that Eric Menendez, during his second trial, testified for 7 days about graphic descriptions of the sexual abuse that he had encountered by his father between the ages of 6 and 18. He also talked about sexual abuse that his brother Lyle had experienced by his father between the ages of 6 and 8. That evidence was brought in, and he was asked about who he spoke to about this sexual abuse during that time period. He said he had spoken to Andy Kano. When did he speak to Andy Kano? He said when he was between the ages of 12 and 13, and Andy Kano was approximately 10 years old. That was before Eric Menendez moved from New Jersey to California, roughly 6 years before these 1989 killings. So Andy Kano also testified in the trial, and Andy Kano relayed the same information, that he had had this conversation with Eric Menendez 6 years before the 1989 killings, when he was 10 and Eric Menendez was either 12 or 13. They spoke several times that year, and that was the only conversations they had about the sexual abuse, only communications they had. So now we have a letter filed in May of 2023 that is supposedly a 1988 letter written from Eric Menendez to Andy Kano about this sexual abuse, never discussed in any of the two trials when Eric Menendez testified or Andy Kano testified. And we believe it's inconceivable, as we've argued in our papers, and defies common sense, that if they had evidence that would show that sexual abuse had been communicated not just 6 years before the events, but 9 months before the 1989 killings, that it would absolutely have come out during one or both of their testimonies. So the fact that it didn't come out, again, goes to whether or not this evidence first was discovered after the trial. If Eric Menendez wrote this letter, he had it or knew about it, or Andy Kano had it and certainly knew about it by the time of the 1993 trials. In fact, it's a 1990, excuse me, a
So is he trying to imply that this letter isn't real or that they made it up? Because we know the story. It was found after Andy passed away in his belongings. They didn't know that this letter existed because, I mean, it was filled with lots of different topics. It wasn't just about that. So I'm not sure that that is a viable argument that, oh, they should have known that this letter existed. I don't remember every text and message that I ever write to anybody, you know? I mean, I doubt that they knew, or that it was even possible to find, or that it would even help them in this case. You know what I'm saying? Like, they're kids. They were still, 18, 20 years old when this happened.
1988 letter. They would certainly have it by the time of the 1995 trials. So to say that this letter
No, they didn't, sir, because Andy didn't pass away until the 2000s. I can't remember what year it was. Um, but they didn't find the letter until recently. They didn't know of its existence. So I knew this guy was full of crap, and I knew he wasn't going to help the brothers, and that's exactly what's happening here.
Was not discovered after the trial, as it's been alleged in the defense papers, we believe is just wrong. The second thing with this letter is that if the letter was real, then the question is, when is the substantial delay triggered in actually filing this motion? So what you find in the motion is Eric Menendez is saying, I didn't know about the letter until effectively a 2015 special by Barbara Walters, where this letter had been given to her, and she actually broadcast this letter in 2015. But remember, this motion, this habeas motion,
But this was after Andy died. So the letter didn't come into existence until, or it it wasn't known. The existence of the letter wasn't known until after Andy passed away, and Rob Rand, who is a journalist who has extensively written on this case, books and articles, and ever since the trials, he's been following this case. He found it. He found it after Andy passed away, and Andy's mother said, Go ahead and go through his things if you think it would help the brother, the Menendez brothers." And that's when he found the letter.
this second habeas motion, was not brought in 2015. It wasn't brought in 2020. It was brought in 2023. So one of the additional standards for a habeas motion is that you do not engage in substantial delay in bringing this motion. Andy Kano
Maybe they didn't think it was enough on its own.
had long since passed. He passed in 2003. So he was now around to actually cross-examine and see if this letter was an actual letter that he had received or not. Or perhaps he received it, but he didn't receive it in 1988. He received it at some date much later than that.
So he wrote it after he was incarcerated? No, because things that he references in the letter, it's clear that they're not in jail yet. It's clear that the murders haven't happened yet. It's clear that it happened before August 20th, 1989. So that letter because they're talking about camp and things like, going away for camp and whatever. I think that, or somebody was at camp. I can't remember the exact specifics about it, but yeah, they were talking about things that were happening in their lives while they were free and alive, and the parents were alive. So obviously, the letter was written before the crimes happened. So for him to even make that argument it makes no sense, and he's just being disingenuous. He just doesn't want to advocate for the brothers to come out of prison, and that's where we're at. And I knew it because he hadn't made it any kind of committed answer ever since his election. So there we have it.
This particular letter it could have been discovered prior or during the trials, and then wasn't presented it was presented after a substantial delay, even when both Lyle and Eric Menendez say that they had this letter.
And he was a kid when it happened. I mean, teenager, and Eric was 18. So Andy must have been I know Andy's a couple years younger than Eric. So why would either of them necessarily remember that this letter was written? I'm sure they've written each other hundreds of letters. I doubt that they knew that it was in this letter. This the stuff that Eric was talking about, his dad coming into his room at night.
The third standard is admissibility. Let me deal with the Roy Rossello letter to give you an idea how the admissibility standard works. The letter has to be, it has to comply with the admissibility standards of evidence in a court. Now remember, In 1989, August 20th, the issue is what is going on in Eric and Lyle's head at the time they shotgunned their parents 12 times to their death. Are they again have an actual fear of imminent harm and death, that their parents were going to kill them that night? Or was it a willful, premeditated, and deliberate act on their part? What they have said about the Roy Rossello allegations, that he was sexually abused by Jose Menendez in the early 1980s, is they didn't know about this in 1989.
They didn't.
They didn't know about this in 1999
Nope.
or 2009.
Nope.
They first found out about this in 2022, or
Yep.
approximately 2022.
Yes. And what's the issue? Like, why are we questioning everything that they are swearing to in their affidavits and their filings? They're not supposed to lie in court filings, so why is Nathan Hochman like, well, we don't believe anything that they're saying. We don't believe the letter exists or is real, and we don't believe that they didn't know that Rossello was abused by Jose. What? Screw you, Nathan Hochman.
About over 30 years later after the killings. So the evidence, if in fact this is true of what Roy Rossello is saying, would not be admissible to show their state of mind in 1989 because they didn't know about it in 1989. So again, it would fail the admissibility standard, as we've argued in our habeas.
But it's evidence that corroborates the brothers' defense. It's evidence that corroborates the fact that Jose was an abuser. So how he can say that it's not relevant, whatever.
Informal response. The last standard, of course, is credibility. Is this credible evidence? We argue in many different ways it is not credible evidence. The first way of...
You have a sworn affidavit from Rossello, but yet he's sitting here saying it's not credible? You have a sworn affidavit from the individual who is saying that it happened to him.
As I've discussed before, is that if they had this evidence, if this letter truly existed, the defense counsel would have absolutely used it at the trial, because it would have helped corroborate both Eric Menendez's testimony about sexual abuse and Andy Cano's testimony about sexual abuse, because that letter was 8 months, roughly 8 or 9 months before the murders, not 6 years before the murders. But it was never mentioned, its contents were never mentioned, it was never produced or in any way used during either one of the two.
Because they didn't know. Am I on crazy pills? What is wrong with all of our DAs that don't understand the law? I mean, I understand it better than they do, I think.
Trials. But the notion that this letter could be part of a continuum of lies and deceit and fabricating stories required us to go back into the history of the Menendez case to analyze whether or not that would be true.
Here it is.
And
when we call them liars, you're gonna call them liars and just not credible people and horrible. Here we go. Okay, they're just gonna disparage the brothers. Cool.
That. What we found out is that Eric and Lyle Menendez had told 5 different versions of the events of what had happened. The first version that they told is that they did not kill their parents. This was the version they told when they were first confronted, or they first made their 911 call. And they said that someone had murdered their parents, obviously not them. When they confronted the police, and the police showed up that night, they ran out screaming and crying that their parents had been murdered. They'd come home and found them that way. They didn't admit it themselves. That they went ahead, and in that version again, they said it was a mafia hit. And they had the police investigate whether or not Jose Menendez had been killed by the mafia. That was
It wasn't the brothers who came up with that idea. They just kind of went with it when it was discussed.
First
Am I
version.
wrong about
The
that?
second version was that their father was a violent sexual predator who raped Lyle's girlfriend. This was a version that was shown when Lyle's girlfriend
And the brothers admitted to all of the things that they lied to and misrepresented. They admitted to all of it.
came forward and said that Lyle had confronted her and said that he wanted her to testify that his dad had violently raped her and that he wanted her to testify to that at trial. She refused to do so. The third version that Lyle told was that their father had molested Eric, but the mother had molested Lyle, without any mention of Lyle being molested by his father. Again, that version ultimately didn't show up a trial in their defense. The fourth version is that Eric and Lyle were both molested by their father, and the fifth version is that both their father and their mother were going to kill them the night of August 20th, 1989, which is why they shot them first. And I want to focus on the difference in many respects between the fourth and the fifth versions. Because
There really aren't that many differences. You're just trying to make it that way, but cool.
again, the key for the trial is basically what happened that night. What was in their head that night? Sexual abuse is abhorrent, and we will prosecute sexual abuse in any form it comes. But sexual abuse in this situation, while it may have been a motivation for Eric and Lyle to do what they did, does not constitute self-defense. And that's why Leslie Abrahamson said back in 1993 that sexual abuse does not justify killing your parents, and that they would never argue that. So, what happens in this continuum is we analyze
They're not trying to justify it. They are trying to prove that they were in danger, that these people were dangerous people. I think that's what that proves. All the new information, the new evidence that you're just poo pooing and saying it's all fake, it proves that Jose and Kitty were dangerous and the brothers were scared of them from a lifetime of abuse.
some of the examples of the lies and the differing stories that have been told, is that we actually saw stuff that was lied about before the killings, during, at the time of the killings, and in the months and years afterwards. And this evidence ranges from everything, including days before the killings, the Menendezes didn't go ahead and get their shotguns in Los Angeles and use their real names. They drove down to San Diego and used a fake ID and a fake address.
I just want to say that Nathan Hochman isn't like coming up with anything new. He's not saying anything new. He's basically just reiterating the prosecution's case from the beginning, which doesn't change the fact that the brothers never should have been prosecuted for second degree homicide. It always should have been manslaughter, and they should be out by now.
Of one of Lyle's friends. Hours before the murders happened, they came up with a pre-planned alibi where they had actually gone ahead and contacted one of their friends to say that they were going to go to Batman the movie that night, and they would meet the friend afterwards at the Taste of LA event. During the murders, the way that the murders actually happened was instructive to understand the deceit and the planning that went into it. There was over 12 shotgun blasts that occurred that night. One
I
of the
don't know that.
shotgun blasts was to Jose Menendez through the back of his head. After he was
The prosecution has always tried to exaggerate how many shotgun or how many times they were shot, and you can't really tell because of the ammo that was used because it creates a lot of damage when it goes off. So that is why like one shot at the that got Jose might have also gotten Kitty. So you can't count each and every wound. And that's always been a discrepancy that we don't know how many times they actually were shot. I mean, there's they can guess somewhere between, you know, this number and that number. They like to say 12, 14. It's been so that has been something that we don't know for sure, but he's just going to put it out there as fact.
Was dead, there were shotgun blasts to each one of his knees. The shotgun blast to the mom initially didn't kill her. She actually ended up lying on the ground, groaning and bleeding in pain. And that's at the point where Lyle and Eric Menendez had run out of ammunition, reload, and Lyle puts the reloaded shotgun up to his mother's face and pulls the trigger, thus staging it at the time like a gangland hit, which then becomes their deceit and lie in the ensuing months that occurred.
He's misrepresenting facts. The brothers did not stage anything. The only thing they did was pick up the shotgun shells.
Then you had the deception that occurred where they hid the evidence of their crime. They had the wherewithal that night before they left the house to pick up each one of the shotgun shells that had been expended. They then had the shotgun shells with them. They had the bloody clothing and the shotguns. And they proceeded to go to Mulholland Drive to dump the shotguns and to a car wash's dumpster to drop off the shotgun shells and their bloody clothing. Then they
We know all this. Like, what? This isn't new information. We know all this. This doesn't change the fact that they should be out.
decided to execute the pre-planned alibi. Again, the deliberate, premeditated state at this point where they went ahead and they actually went to the movie theater to get the tickets for Batman the movie. Turns out that they couldn't get the 8 o'clock tickets because it was already past 10 o'clock. Then they called their friend to meet him at the Taste of LA, but by the point they got there, he'd already moved on. Then they actually called a friend to meet him again in another restaurant, and they never show up. Eventually, that friend comes to the house later that night, only to see police tape around the house. Now, after they were arrested, the Menendezes also tried to suborn perjury in a number of different respects. They contacted one of Lyle's girlfriends, Tracy Baker, gave her an actual script, a script that was actually found by the police, where it said that they wanted her to testify that Lyle's mother, Kitty Menendez, had poisoned them, had poisoned the whole family.
That is an allegation that the brothers do believe happened, and Jose accused Kitty of doing that all the time, of poisoning them. And he would get up and leave the house and say, "Boys, we're not eating here," and he would take them out to dinner. This has been testified to.
She actually did testify to this extent in the first trial, but didn't testify to this in the second trial. They also contacted one of Eric's friends, Brian Eslamania, and asked him to falsely testify that Eric and Lyle Menendez were so fearful of their parents the weeks before the murders that they tried to borrow a handgun from Eslamania. He wouldn't testify to this. They also, again, as I mentioned before, asked...
It doesn't mean it didn't happen, but I don't know. I don't know for sure if that was a lie or not, but it doesn't mean that it didn't happen. Just because he didn't testify to it doesn't mean it didn't happen.
A different girlfriend of Lyle if she would testify that Jose Menendez had violently raped her, and she wouldn't do that either. Finally, when it dealt with the handguns themselves, the Menendezes both testified that they had gone to the Big Five Sporting Goods in Santa Monica to actually buy handguns before they switched to the shotguns. But it turns out the Big Five Sporting Goods in Santa Monica in 1989 didn't sell handguns. So we looked at, again, the credibility of the letters, and particularly this Andy Cano 1988 supposed letter, weighed it in the continuum of lies, and it calls into drastic question whether or not this is in fact a 1988 letter written by Eric Menendez to Andy Cano about this sexual abuse. But again, even if it is, it's not timely because it was not presented at the time of trial. They substantially delayed in bringing this motion from at least 2015 to 2023, and in certain respects, it's also not admissible, which is why we conclude in our informal response that the court should deny the current habeas petition by the Menendez brothers. And if the court decides not to deny it at this point, the next motion or move for the court is to order what's called an order to show cause. Then we will file this response in response to the order to show cause. The Menendezes can reply, and the court can rule at that point or have a hearing in the habeas matter. So this is what we have been up to with respect to the habeas petition. Again, as I mentioned before, the governor has the clemency petition on his desk, and he can do whatever he wants, whenever he wants, and we will be dealing in the next couple weeks with the resentencing issue. Let me stop at this point and take questions, and at the end of this, I'll have Maria Ramirez address the Spanish-speaking audience on these issues.
Yeah, the family
Right here.
has been pushing for this. What did you tell them when you told them that you weren't going to support it?
So what I said to the family is that I would listen to them.
That's a good question. Like 20 plus members of the family want the brothers out. And this asshole is like, nah.
And we did. We met with the family for hours, and I heard all the issues that they have and all the concerns that they have and all the experiences that they shared with me during those conversations. Much of that deals with rehabilitation. Rehabilitation is not an issue for the habeas motion. And I want to make that crystal clear, that all the talk about rehabilitation will be talk that will be focused on in the resentencing motion. But as I mentioned before, the habeas motion focuses on the evidence at trial and any new evidence that might materially affect the outcome of that trial. Yes?
It seems that your examination of the case file so far has been significant. You demonstrate clear mastery of what you've seen. But it also sounds like you're casting doubt on the brothers' assertion that they were serially sexually abused by their father.
Again, what we have done is we've gone through all the evidence at the trial, which is the evidence that we have to work with. We looked at any testimony that was given by Eric and Lyle Menendez in the first trial, or just Eric Menendez in the second trial. We looked at all testimony that was given in support of the defense in either trial. We looked at any additional statements that we were given of people who had any level of percipient knowledge of the sexual abuse. We certainly looked at any other circumstance that deals with this question. And in looking at that, again, as I point out, that was the fourth version of what was told by the Menendezes in real time back in the 1990s.
So having reviewed 50,000 pages of documents, etc., do you personally now believe that they were not sexually abused by at least Jose Menendez?
What I believe is that they testified to that sexual abuse. They absolutely testified to it in great detail. I also understand that when it came to any corroborating...
We're back in the Stone Ages where we don't believe victims and we don't believe that boys can be abused by their father, I guess, and mother. I guess we're in the Stone Age.
information about that sexual abuse, it was extremely lacking. In fact, there were other...
He just said that it was lacking evidence of the abuse. Excuse me? We watched the entire trial. There is absolutely no way that it is made up. So many family members corroborated it. So many aunts, uncles, all of the cousins that had lived with them. This has been corroborated by so many. And here he is denying it. Again, and it's uncontested. They never even contested it back in 1993 that the abuse happened. So for them to take the stance that it never happened now makes no sense to me.
And the fact that it was their fourth version. In other words, they didn't come out initially and say, we killed our parents because our father sexually abused us.
Usually victims of abuse don't want to talk about it.
They didn't go ahead and when they got arrested, tell anyone that. They were saying it was a mafia hit and somebody else did it. They then, once they were arrested, they didn't again come out initially and say my father sexually abused me. In fact, just the opposite. They were trying to say Lyle's girlfriend was violently raped by the father. Then the next version wasn't that the father sexually abused both of them. The father sexually abused Eric, but the mother sexually abused Lyle. So then you finally, and then you had, as you're aware, the Dr. Oziel tapes, where they didn't believe those tapes would ever be made public. But in those tapes, where Eric had gone to Dr. Oziel because he was suicidal and he needed to tell someone that he had actually killed his parents. At no point in any of those conversations that occur in late 1989 does Eric say that he was sexually abused by his father and that was any reason or played any role in what happened. Lyle, who's also interviewed by Dr. Oziel on tape, doesn't discuss that as well. And with respect to the mother, here's what they told Dr. Oziel. They said that they had killed the mother because they didn't want her to be a witness to the crime. That was
That's not true. And everything on those Oziel tapes was basically Oziel talking and telling the brothers, this is why you did this. This is why you did it the way you did it. It wasn't really the brothers actually talking about it or confessing or telling truth because they didn't trust Oziel. They couldn't trust Oziel enough to trust them with the talk of the abuse from Jose. They couldn't even trust him to talk about that. So why would they talk about all of it? It just doesn't make sense.
reason one. The second reason they killed the mother is they thought that she was leading such a miserable life because the dad was cheating on her that they basically thought that they were doing her a favor, which was the third reason, which is effectively
Again, that's Oziel who said that, not the brothers.
a mercy killing, whereas Dr. Oziel testified euthanasia as to why they were killing the mother. At no point do they tell Dr. Oziel the father was sexually abusing them and the mother condoned it.
So just to be crystal clear, you're saying that the evidence does not exist that they were sexually abused by either parent?
What I'm saying is that the evidence, to the extent that evidence can include their own testimony, certainly that evidence exists. Eric Menendez testified for 7 days in the second trial in graphic detail, incident by incident, describing the sexual abuse he experienced by his father. Andy Cano talked about a conversation he had when he was 10, not when he was 16, but when he was 10, and Eric was 12 or 13, where Eric was describing that sexual abuse. So if you're asking me, was there evidence presented in the trial about it, there certainly was. If you're also asking me, has new additional evidence come out about that beyond the Andy Cano letter, there is none, or at least it certainly hasn't been discovered by the prosecution and hasn't been presented by the defense.
Is that what you're saying?
Yes.
Have you tried to authenticate that letter?
We've asked for an original copy. The only way to truly authenticate that letter, there's only 3 ways you can do it. One, you need the original copy, or you need an envelope with a postmark. We've not been presented with the original. We've not been presented with an envelope with a postmark. The second is Eric Menendez. He himself, in a declaration under penalty of perjury, has said that he wrote that letter in December of 1988. And the only third person who could probably authenticate that is Andy Cano, who passed away in 2003.
Mr. Attorney, do you believe that the Menendez brothers should be freed?
The question about whether or not the Menendez brothers should be freed will ultimately be a court question. Our job is to give the court the information and make the arguments, and particularly, and again, when it comes to the habeas motion, let me just start with the habeas motion, because that's what's teed up here. The Menendezes are asking for a new trial. In a habeas motion, I want to make this clear, you would not get off. You would not get released if you win the habeas motion. You would get a new trial, which is why I've gone through the trial evidence to show you where the new evidence overlaps with where all the voluminous trial evidence already exists. So at the end of the day, with respect to the habeas, you would not get freed in any event, even if you won. And as I said, with respect to this habeas, we believe it should be denied.
Have you just laid out a case, though, that Governor Newsom at least should think twice before he would even consider granting clemency?
I hope what Governor Newsom will do is what we have done. Certainly, we will, if he doesn't already have the 50,000 plus pages of trial transcripts, we'll make that available to him. I hope he speaks to prosecutors, defense attorneys, the Menendez family members. I hope he reviews all the rehabilitation records. You know, those also are voluminous, but they play in the resentencing motion. The clemency power he has is vast. It's unilateral. He can do it literally today. He could do it tomorrow if he chooses. He can also do nothing. Now, one example, well, that is the power that he has with respect to it. And as I pointed out as well, and this is an interesting aspect of the governor's power. When it comes to resentencing, let's focus on that for a moment. what you'll have is that there'll be a resentencing hearing at some point. The judge makes the final call there. The judge can keep the sentence as life without the possibility of parole, or he can change the sentence to life with the possibility of parole. Let me play that out for you for one moment. If the judge, not the prosecutor, not myself, but the judge makes that decision at the hearing, then what will happen is it'll go to the parole board. That's the next stop in the chain of events. The parole board will then have a parole hearing at which Eric and Lyle Menendez will present the reasons why they should get parole. The parole board itself can make one of two choices. It can recommend the granting of parole, or it can recommend denying parole. And then guess who gets the case at that point? The governor. The governor then has 120 days to do one of three things. He can affirm that grant of parole, and they would be released. He can he can modify, or he can actually reverse the grant of parole, and then they will not be released. And there's no appeal at that point. Now, as an example of where the governor has exercised the power to reverse the parole board, I point you to the case of Sirhan Sirhan. Sirhan was the assassin of Senator Robert F. Kennedy back in 1968 in Los Angeles. He was originally given the death penalty, but the Supreme Court overturned the death penalty, so he got a life with the possibility of parole sentence. For 40 years and 15 parole hearings, Sirhan had his parole turned down by the parole board. But on the 16th hearing in 2021, the parole board for the first time went ahead and granted parole. Then it went to Governor Newsom's desk. He looked at the fact that Sirhan had been in jail or prison for over 50 years. He was in his late 70s. He was in diminishing health. But Sirhan had never fully accepted responsibility for the actions that he engaged in. So the governor determined him to be a danger, notwithstanding all other factors, and actually reversed the parole grant for Sirhan, who remains in bars today. Yes, right here.
It would seem, just sort of big picture, hearing everything you're laying out right now, it would seem like you are leaning towards not recommending they should be resentenced. Is that fair to say?
So with respect to resentencing, we have not finalized where we're going to end up because it's not just the trial analysis. It requires an additional substantial analysis on the rehabilitation factors and other factors that are very unique to the resentencing statute. We estimate within the next 2.5 weeks, we'll be filing something at that point, and then we'll make our position very clear. Let me take one in the back. Hold on one second. Let me take one in the back.
You're essentially saying that the Cano letter is not admissible and the Rossello declaration is not admissible under the habeas structure. Is that right?
So the Cano letter actually would not be timely because we believe, for as far as Eric Menendez is concerned, it's a letter that wouldn't be discovered after trial since he wrote it in December of 1988 and the trials were in 93, 95, and 96. As for Lyle Menendez, it would not be admissible because, again, it's an out-of-court statement not dealing with Lyle's situation but dealing with Eric's situation. For the Roy Rossello declaration, we're saying that is inadmissible because a declaration about incidents that occurred between Roy Rossello and Jose Menendez in the 1980s that the Menendez brothers didn't know about to the 2020s, we don't believe could influence their state of mind when they actually killed their parents. So it couldn't play a role in self-defense or premeditated murder. Yes.
When it comes to the factors and the assessments that you outlined today as it relates to the habeas petition, can you elaborate on whether any of those factors and assessments will play into your review of the case when it comes to resentencing and other factors that you would consider?
So yes, we'll certainly look at much of the evidence that we've discussed today as it pertains to the trial. But the resentencing motion goes beyond that. It really focuses as well on rehabilitation. It focuses on other factors that are identified in the resentencing statute. And that requires this additional analysis, which we are in the process of engaging in, and then we will finalize our position within the next 2 to 2.5 weeks. Yes, right next to you. Hold on one sec.
Governor Gavin Newsom has previously said he is waiting for you to review the case before taking a position on potential clemency. So what would you tell him outside of the fact that you want him to review the case? Would you give him your thoughts and opinions?
So I tell him to review, I think it's 88 pages, the 88 pages that we have filed today as a starting point, as well as the voluminous exhibits we include with it, including a lot of the trial transcripts, so that he can review for himself what went on at the trial. We will also, when it comes time for resentencing, deal with the rehabilitation aspect. We'll provide Governor Newsom with all that information as well to review. He can find some other source that he wants to review, talk to anyone he wants to talk to add to his database of how he wants to make his decision. But ultimately, the governor, again, he has absolutely unilateral, full power, constitutional power to commute that sentence. He can, and again, you might have the issue coming up on a parole issue if it comes through that path, but the clemency power exists separate and apart from habeas and resentencing. A question over here.
So when it comes to rehabilitation and resentencing, Lyle and Eric just did a podcast. They came on, and two angry men. I don't know if you had a chance to hear it, but essentially, they talk about their whole rehabilitation process that they've been through, all the work that they've done with people, all the brutalization that they face behind bars. And I wonder what your thoughts are about that, because I know you've been looking into it.
So part of a good amount of the rehabilitation evidence was in the original resentencing motion filed by the prior district attorney. And you can go, it goes on for tens of pages detailing the rehabilitation that both Eric and Lyle Menendez have done over the last 30 plus years while in prison. To the extent, I don't know if they said anything, I have not viewed this podcast beyond what's already in the prison records that are very detailed about what went on in the prison. But again, to the extent that they want to supplement any information that the court's going to have, I'm sure through their counsel they'll do that.
And do you believe that they've been rehabilitated based on all you've looked
It's again, in our resentencing position,
He's not going to commit to an answer to that. Not until after they file their response to the resentencing.
we will deal with the full scope of our thoughts dealing with rehabilitation in the context of resentencing, because that's what's important. The resentencing statute focuses certainly on rehabilitation, but other factors, and we'll make our position known like we've done it here today in the habeas position when we file our papers. Let me take another question back there.
There are many Menendez supporters all over the world who believe that they were sexually molested, and they say they've served more than 30 years. Isn't that enough? They'll obviously be very disappointed after this news conference. What would you like to say to that?
So what I would say again is that there are three different paths that the Menendez case is on right now. This particular path of habeas is a very specific path with very rigorous standards on how you get a new trial. Again, even if they won the habeas motion, they would not get out. They would just get a new trial. And we've gone through it fairly methodically in this press conference, and even more methodically in the informal response we submitted today to explain why we do not believe under these rigorous standards they qualify to get a new trial. Again, much of what they are arguing in this second habeas position has been already brought to a trial judge who's rejected it, the direct appeal, which is the California Court of Appeal and the California Supreme Court, which has rejected it, back to the California Supreme Court with the first habeas petition, then over to the U.S. District Court and the Ninth Circuit Court of Appeals, rejected. So most of the arguments they brought in, other than those two new pieces of evidence, have been rejected by every single court that has heard them. So again, with respect to the habeas petition, I don't know if people understood what was involved with the habeas petition and how very specific and narrow it is. But that's why I've done my best, both in this press conference and in the video that we put out, to explain how these processes work. Yes, over here.
The previous district attorney wrote letters to Governor Gavin Newsom in support of the brothers' bid for clemency. Would you do the same?
I'll let our filings speak for themselves. So if the governor, and I'm sure that if the governor wants to get a hold of my informal response today, if he wants to get a hold of any pleadings we file in the resentencing case going forward, if he calls me up, I'll be happy to send to him, but they're available publicly. And in fact, we'll put them on our website, da.lacounty.gov, and the governor can access them there.
Have you made a decision yet, even if you're not telling the press?
We have not made a decision on the resentencing issue. We're still in the process of not just analyzing the trial evidence, but analyzing the rehabilitation and all the other evidence that's required in a resentencing motion.
District Attorney, you haven't spoken to the brothers yet, and we know you don't have to. Would you like to?
Again, it's not, the defense counsel has never offered to make the brothers available for me to speak with personally. Whether I speak with them or not, starting with the habeas petition, is irrelevant. Because again, what this focuses on is a very narrow legal standard on whether or not the new evidence, these two new pieces of evidence, meet all those standards I've gone through, warranting a new trial. With the resentencing, again, the Menendezes have put letters already that they have written in connection with the resentencing. We've read those letters. We will be considering those letters as well as all information that the defense has provided. I don't believe actually my speaking with the Menendezes one way or the other would influence what I ultimately come down and do. The record is very voluminous and I believe very complete. Next year stuff.
Do you believe, times have changed and maybe now we have a better understanding of what it's like to process childhood sexual abuse? Looking back.
I mean, I think that we've certainly, our abilities to understand it over the last 30 years have certainly improved. But the question back, and this is why I focus on what Leslie Abrahamson said about the role that sexual abuse played at the trial. As she said, sexual abuse does not justify killing your parents. It doesn't that day, and it never will. And that's why I want to make crystal clear. That came from Eric Menendez.
I'd like to know the rest of her quote there, though, because he might just be taking something that she said out of context.
Menendez's counsel in 1993. And so, again, whether or not sexual abuse understandings have improved over the years, certainly as it affects this habeas petition, has no bearing. Yes?
regarding the sexual abuse defense, just how much will that factor into the resentencing decision, whether or not the brothers were sexually abused?
Again, everything I've said today will certainly be part of what we consider in dealing with the resentencing motion, but we're going to go well beyond this. Today's focus has been on the trial and the evidence presented at the trial. The resentencing motion will consider that certainly, but they can keep going over the next 35 years beyond that. Let me take one more question.
So, any feelings about?
Actually, in the corner there.
In meeting with the Menendez relatives, what are your thoughts on what they've had to tell you? And have you also met with Milton Anderson, Kaylee's brother?
So my thoughts about, again, the meetings that I had with the Menendez family members, it lasted approximately 3 hours. Each one of them was invited and did to say to me anything they wanted to say for as long as they wanted to say it. And we sat there, we listened, we took notes, and we understood what they were saying. I then thereafter had a phone call with Milton Anderson. I had never spoken to him personally until that phone call. Had that phone call, I invited him to say whatever he wanted to say, and he did. That forms part of the compendium of evidence that we will consider in the resentencing motion. It actually does not affect one way or the other the habeas petition that we have filed our informal response today. All right, thank you all very, very much. I very much appreciate it.
Response to the mayor's abrupt firing of Fire Chief Crowley?
No, no response on the Menendez press conference.
Any comment on how the ASAP Rocky trial ended?
And no comment on ASAP Rocky. Today was about the Menendez case. Thank you very much.
All right, so that is the end of that press conference. Wow, just made me angry. I think the only thing we really learned from that is that Nathan Hochman is not friendly to the Menendez brothers, nor does he understand abuse in any way whatsoever, or how people react or deal with abuse. He has no clue, and that's obvious. I don't even know what to say. I will look for that brief that they wrote, and we can go over it on my channel if I can find it, and also that video that they said that they were going to release. I couldn't find it at the beginning of this press conference, so I will go back and look for it and maybe do a follow-up video to this if I can find that. So I will let you guys know more as it comes out. We know he says in about 2 weeks or so he's going to respond to the resentencing. So at this point, he's denying the habeas. He says clemency can happen at any time whenever Gavin Newsom decides to do it, if he does. And at this point, he's they're still reevaluating the resentencing rehabilitation information that uh, they need to evaluate to look to respond to that motion or motion for resentencing. So they will respond when they do, I will go over their brief. So let me know if you guys have any questions, comments. This was disappointing, but I'm not surprised. And I don't think he's going to be very friendly for the resentencing either. Just heads up. But good thing it's not up to him. So it's up to a judge, and the judge is going to look at the law, and the law states these brothers, there's no better candidate to be candidates to be given a resentencing for their crimes. So thank you guys so much for watching, and I will see you guys in the next one. Take care. Bye. Whoops.